Hello, everyone, and welcome to Criminal Law 1, Constitutional Criminal Procedure. We have journeyed from the investigatory phase through arrest. Now we're beginning to look at the rest of the phases in terms of what your rights are at each different point during the trial process. So this is usually going to begin with what's called the initial appearance. So the initial appearance, sometimes it's referred to as the first appearance, is generally the first formal adjudicatory step following an arrest. Okay? So this is what's going to happen after a prosecutor files a complaint. It may also happen after a grand jury indictment. Remember, a true bill. Now, per County of Riverside versus McLaughlin, 1991 case, the initial appearance must occur within 48 hours of the arrest. Now remember, back to interrogations, the McNabb-Mallory rule provides a confession obtained after 48 hours without an initial appearance is inadmissible. So basically, what has happened is McNabb and McLaughlin, they work together in such a way that police can detain you essentially for 48 hours and just let you go. Now, you can always sue for violation of your constitutional rights. Those suits are very rarely successful. Police know this. So that being said, 48 hours is our benchmark, but you can always try to make a due process argument that you were being unfairly held or something along those lines. So what happens at the initial appearance, right? Well, there's four primary purposes. Now, the first is notification of the criminal charges. Right, so this is usually informal notice. So until the arraignment in the grand jury jurisdiction, we tell you what you're going to be indicted for, right? And here we have just an initial determination of probable cause. So does it look from a very high level like there's more reason to believe that a crime was committed and that you are the person who committed the crime than not? If there is, again, from a very high level, without much debate, then we're going to say there's enough to move forward. Now, if there's not enough probable cause, again, at the very high level, so this is even a more lax standard than normal, if we say there's not enough probable cause, then you have to be released. Right, immediately. In addition, at this stages, so one thing that will happen, guaranteed at the proceeding, is that the judge will read the suspect his or her the defendant, I should say at this point, his or her Miranda rights. Now, this is done, right, partially because we want to make sure that the person is fully apprised of the Miranda rights, but also with the realization that now we're talking about appointment of counsel in a lot more detail. Right? So they're going to advise the defendant of their Miranda rights. You're going to advise them of the availability of pretrial release. They're going to advise them of their right to a speedy trial. And they're going to advise them to their right of a preliminary hearing, also known as a probable cause hearing. So this advisement will only happen in non-grand jury jurisdictions. right? Because remember, grand juries are tasked with finding probable cause. So grand juries are tasked with finding probable cause. As such, we don't need a preliminary hearing, because that's the whole point of the preliminary hearing, is to find out whether there's probable cause or not. Now, as I've said before, generally speaking, defense counsel would prefer a preliminary hearing before a grand jury hearing or grand jury indictment. And this reason is basically that the preliminary hearing, the defense does not get to call any witnesses, but the defense does have the right to cross-examine. So what happens is the prosecution calls their witnesses, right, presents their evidence, basically giving a full preview of their case to the defense, and the defense gets to ask questions, right, to see how well this person will hold up. So preliminary hearings are preferred by defense attorneys because grand juries are not. And grand juries are not because they are sealed. So the only people allowed in a grand jury room are the prosecutor, the witness, and the grand jurors. So this means that the lawyer cannot sit in there in the grand jury room. And again, remember, we've discussed about grand juries indicting, like the old saying from the famous New York State judge, a grand jury would indict a ham sandwich, right? So grand juries are the prosecutor's playground. Really, the grand jury is going to do whatever the prosecution tells it to do. Now, that being said, that's why some of these more recent events in terms of police use of force and police violence have become really troublesome, at least to those in the legal community, is because a grand jury will generally always do what the prosecutor asks them to do. Now, the prosecutor's job is to go in there wanting to obtain probable cause, wanting to obtain an indictment. Right? So when grand juries don't return indictments, it makes you question whether or not the prosecutor had just motives. And that's where it becomes troublesome, right? Where probable cause is such a low threshold and all they hear from is prosecution witnesses, right, you're always going to indict. And that's where it becomes troublesome. In addition, the prosecutor can always dissolve the grand jury, right? So let's say they present a case in front of the grand jury and the grand jury finds a no bill, right? Doesn't indict. The prosecutor can dissolve them, can say, okay, you're dismissed, convene a new grand jury, and then try to get a probable cause or an indictment out of them. And the prosecutor can do this as many times as he or she pleases. You are not barred by double jeopardy at this point, right? This is just that investigatory stage. So at this point, this is when the judge will advise if it's a preliminary hearing jurisdiction, you have the right to a preliminary hearing. If it's a non-grand jury jurisdiction, that's when you have the right. If it is grand jury jurisdiction, a lot of times they'll give you a chance to waive the grand jury if you want to. At this point, usually what's also going to happen is we're going to have a determination of bail or pretrial release. So remember that generally speaking, there is presumption that we will give bail in all cases. This started out as a federal presumption and then moved to the states. Now, if there are certain crimes, like certain crimes involving violence or certain crimes that are drug-related and severe enough, then we have a rebuttal presumption against release. right? Which just means that we're to presume that we're not going to release you unless you can put on a good case and tell us why you should be released. So this is determination of bail is probably one of the most important parts of this initial appearance. And the reason I say that is because at this stage, the determination of bail will ultimately determine often how a case goes. So if you are denied bail, the more likely it is that you will be convicted, and the more likely it is that you'll receive a harsher sentence. Well, and the idea is you have limited access to your attorney, you have limited access to anything along those lines. Now, at this point, we'll also appoint counsel. So we'll appoint counsel right from the get-go if you qualify. And we'll talk about how do you qualify for appointment of counsel in terms of money, right? How much money you have and things like that. But we're going to appoint counsel, and the counsel is going to do the bail hearing for you. Now, some jurisdictions may permit the accused to enter a plea, but generally speaking, at this point, they don't, and a presumptive plea is entered on their behalf. And the presumptive plea is that of not guilty. So when we think of the concept of bail, bail is largely governed by the Eighth Amendment. The Eighth Amendment provides in relevant part, excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. Now, the exact language of the Eighth Amendment is key. Specifically, excessive bail shall not be required, with emphasis on excessive. So when we think of bail, there is not a federal constitutional right to bail. Instead, the Eighth Amendment is triggered only if bail is granted. Right? So we'll say that again. There's not a constitutional right to bail. But if we do decide to impose bail, it cannot be excessive. Now, that being said, many state constitutions provide a right to bail, except in capital cases. So many states say you have a right to bail unless it's a death penalty case, or if it's not a death penalty jurisdiction, unless it's a chance of life without parole, right? Because in those instances, regardless of how much the bail is, if you can make it, you're probably going to run, right? And that's what kind of brings us to this idea of the purpose of bail. So the primary purpose of bail is to guarantee the defendant's appearance at trial. So that's the whole point of bail. It's not punitive. It can't be punitive. It is just you put something up so that we know that you're going to come back to court. Now, under the Eighth Amendment, it must be the minimum necessary to ensure appearance. So anything above the minimum necessary to ensure that the defendant reappears is an Eighth Amendment violation, right? So this includes 1 penny, right? So if we think that the person will reappear for $100 and we impose a bail of $100.01, then we have violated the Eighth Amendment. Now, that being said, when we think about bail being just the minimum necessary for the defendant to return, we do have a pretty significant problem. So generally speaking, only 62% of defendants make bail when it's granted. So this includes both surety jurisdictions, so recall when we talk about bail bondsmen, and money bail jurisdictions, right, where there's no bail bondsman, but the bonds are, and then the prices are lower. That should tell us that we're probably not doing something right. Only 62% of defendants can make bail, then we're generally speaking probably imposing too high of bails, because theoretically 100% should be able to make it. Now, we take into account a lot of factors, of course, severity of the crime, likelihood of fleeing, etc., but it's still a very low number. Now, that being said, in some instances, we may release someone on their own recognizance. This is also referred to in legal shorthand as ROR. Right? It may be appropriate in some cases, but what we found is it is rare, right? But it's effective. So ROR basically means you don't have to put up any money. You don't have to put up a bond, anything like that. We just trust that you're going to come to trial or that you're going to come back to court. Usually these are very low-level cases where the defendant has a lot of interest in the jurisdiction, so they live there, they work there, they have a decent job. We know they're probably not going to get imprisonment, so we don't want them to lose their job. There's a lot of factors that go into it. And it is very rare, but as we've seen, it's actually very effective. Most defendants who are released on their own recognizance do return for trial. Now, why is making bail so important? Well, there are 3 legal reasons and 2 practical reasons. So the first reason why making bail is so important is if we avoid pretrial detention, it sustains the presumption of innocence, right? So remember, when somebody's charged with a crime in the United States, they are presumed not guilty. But if we put somebody in pretrial detention, in jail, then, and we require them to give us money, or we put somebody in jail and we don't give them bail, doesn't that kind of rebut the presumption of innocence? Right? Because it's almost a presumption of guilt. Right? Like, well, you probably did it, so we're gonna presume you're innocent, but not really. Right? It's a little tongue in cheek. Next legal reason is you want to avoid personal hardship that accompanies pretrial detention, right? So that the presumption of innocence has a meaning. And so what we mean by this is if you are bound over for trial and you don't get bail, right? Presumption of innocence comes into play, but we also would assume that if you're presumed innocent, you shouldn't lose your job. You shouldn't lose your home. You shouldn't lose your family. But if you are in jail because you can't make bail, then yes, you run the risk of losing your job, right? Of losing your home, of losing everything. But theoretically, you're presumed innocent, right? So there's such a significant hardship that accompanies bail that really kind of messes with the meaning of the presumption of innocence. Now, the last reason is a very important one. It is this notion that if a defendant can assist in their own defense, right? This is a due process right? Your defendant is able to assist in their own defense. It is generally speaking rendered more effective by pretrial release. And it makes sense when you think about it, right? Because when you are in jail, you cannot help your lawyer, right? You can't help track down witnesses. You can't do really anything except meet with your lawyer in a room with no cameras and no microphones. That's basically soundproof whenever the jail allows visiting hours for lawyers, right? So a lawyer can't go in at 3 a.m. But theoretically, if you had some kind of problem and you were on the outside, you could call your lawyer at 3 a.m. Now, you probably get an answering service unless it's emergency, yada, yada, yada. But again, you can't assist in your own defense if you're in jail. You're in there like any other prisoner. So what we've seen is that if you are able to assist in your own defense, then generally speaking, your outcomes are a little bit better. So that kind of brings us to our second point about the importance of bail. So making bail is critical for 2 practical reasons. So statistically, defendants who are unable to make bail are more likely to be found guilty and receive less favorable plea deals than others. Right, so we'll break that down. Statistically speaking, defendants who are unable to make bail are more likely to be found guilty than others or receive less favorable plea deals. Right, so now there's a question of causation and correlation here. If we bind somebody over, we don't give them bail, chances are the prosecution has a very strong case, and we're talking serious crimes. Right, so there might be correlation, not necessarily causation, but we see that in less serious crimes, that if you are in jail, you are more likely to be found guilty, regardless, right, of what the evidence necessarily shows. Now, in this setting, defendants are usually less likely to receive favorable plea deals, right? So favorable plea deal is obviously you have some bargaining power, right? Because the truth be told, the prosecution never wants to go to trial. The defense never wants to go to trial. The judge doesn't want to go to trial. The jury doesn't want to go to trial, right? Because it's a very expensive, long, drawn-out process. So prosecutors have an incentive to essentially offer good deals to defendants who are on the outside, to keep them on the outside, and let them continue their lives, because otherwise you're probably going to be able to try and assist in your own defense and fight the charge. If you're in jail, you may take a plea deal, anyone that is offered, right? And there's a couple of reasons. One, prosecutors know that if you stay in jail long enough, because it takes so long to get to trial, at some point they'll come to you and say, if you plead guilty, you can walk out of here today. And if you are talking about losing your home, losing your family, losing your job, whatnot, that might sound very, very good, even if you're innocent, right? So imagine you're sitting in jail for a year, you're looking at like maybe another year in jail, you're not guilty, but prosecutor says, you can leave today. And it's not necessarily the most serious of charges, but it could be the serious of charges. You're probably going to make that deal. Now, usually we're not talking about walking out. Usually we're talking about years imprisonment. So if you're unable to make bail, generally you're going to get a higher plea deal in terms of years of imprisonment than if you are able to make bail. Now, additionally, statistically, defendants unable to make bail receive much harsher sentences. So disproportionately, they are the maximum sentence than those who made bail. So again, this brings in causation or correlation. But when we think of this, we kind of have to think of an even playing field, right? So person A commits crime 1. Person B commits crime 1. Person A gets bail. Person B does not get bail. Person A gets a sentence of 6 months in jail. Person B gets a sentence of 2 years in prison, right? So when we say like, if everything is equal, everything being equal, if you're unable to make bail, you're going to receive a much harsher sentence than those who did. Disproportionately, it's going to be the maximum sentence, right? So we'll talk about this later, but in the law, we have minimum sentences, maximum sentences with certain guidelines, and we'll talk all about that in a later lecture. Now, we're going to backtrack just a little bit, right? So when we think about the Eighth Amendment, right, we said that generally speaking, there is no federal constitutional right to bail, right? This is true. But Congress enacted the Bail Reform Act of 1984. And what this does is it creates a rebuttable presumption of pretrial release. So what this means is, yeah, we can set a bail, but we're going to presume that we're going into it with, you can go on your own recognizance or you're going on bail. But the prosecution can rebut that presumption, right? And say, well, even though everything being equal, they're supposed to go free, we need to hold them in preventative detention, right? So generally speaking, we can only hold someone in preventative detention, basically require bail or not allow bail at all, upon a showing of what the standard is clear and convincing evidence, subject to cross-examination of a few factors. So when we think of clear and convincing evidence, right, so we've talked about probable cause being 50.01%, 50% in a feather, 51%, however you want to conceptualize it. Clear and convincing evidence is around 75%, right? It's not beyond a reasonable doubt, but it is higher than probable cause. All right, so we can't just say it's more likely than not they're going to flee. No, we have to be very clear and convincing that they're going to flee. So this gets subject to cross-examination. So defense does get a chance to weigh in and question witnesses as such. Generally speaking, we only will hold somebody in preventative detention if, one, they present a risk of flight, right? So this usually means like, oh, you have 2 passports, right? Maybe you're dual citizenship, or you have a passport, or you have been charged with crimes before and you didn't show up, or you're, again, that's not supposed to be this, but it's a very severe crime and you're probably going to flee. You don't have a job, you don't have any ties to the community, so there's no reason for you to stay. So we look at risk of flight. Risk of flight's interesting because I had a client when I was at the public defender's office who, he was a foreign citizen. He spoke English, but he was he was an interesting person. So he had been arrested in New York City for stealing a credit card and using it to make transactions, right? He is in New York City, he's a international, I mean, he's here on vacation, basically. So he has all the reason in the world to go back to his country of origin, because we're not going to extradite someone for using a credit card to make a purchase at a pizzeria, right? Like, it's just, it doesn't make sense financially. But instead of leaving the country, which is exactly what I would have done, he decided to go to Boston and use apparently the same credit card, which I don't know how they didn't take the credit card, but use the same credit card in Boston. And of course, it gets rejected and he gets arrested. And I get to meet with him, right? And so he did speak English fairly well, but you are entitled to an interpreter if English is not your first language, as a matter of right. So I asked him if he wanted an interpreter, and he said yes. So I told him, okay, just so you know, it'll probably take this, you'll probably have to spend a couple nights in jail until we can find an interpreter that speaks your language. Well, then he didn't like that. So he's like, okay, we're good to go. And like, his English suddenly magically improved. But I had the job of trying to convince the judge this guy wasn't a flight risk, right? Because in New York City, one of the conditions they imposed on him, and he was released on his own recognizance, was he couldn't leave the state. Well, what's the first thing he does is he leaves the state. So I tried to argue to the judge like he wasn't a flight risk, when in all reality, I mean, he literally just fled some charges. But I was like, well, he won't leave the country. So yeah, that was not a fun one, because judges understand you have to make an argument, but if that argument is kind of like ridiculous, they're not going to stand for it. So I was in the mid-sentence, and he said, I'm binding the defendant over for trial. No bail is permitted. Like, he was just mid-sentence, just interrupts me, and then I'm like, oh, okay, well, like, I would have done the same thing too, Judge, but I have to advocate for my client. We also look and see, is this person a risk to the community? Right, so they might not flee, but are they a risk to the community? Now, this again is where we kind of run into that issue about the presumption of innocence. Because if somebody's innocent, then theoretically they don't pose any risk to the community. But we know reality, right? These people have been arrested on probable cause. So that means it's more likely than not they committed the crime. And if they pose some kind of risk in terms of endangering others, then we're probably going to hold them in jail, right? Because we don't want to release somebody, have this person hurt somebody else. We just don't want to risk that, right? So this is usually going to be in serious violent offenses. We're asking, is somebody a risk to the community? This will come up in sex crimes, right? Is this person a risk to the community, or are they just low level, whatever? We also can look and say, may they obstruct justice, right? So we generally will hold somebody if they may obstruct justice. So obstruction of justice is this notion that as the prosecution tries to prove you're guilty, you are doing everything in your power, not through your lawyer, but surreptitiously, to destroy your case, right? And so what we mean by this is, let's say the prosecution doesn't have the murder weapon, right? They can't find it. And for whatever reason, they really need it in this case to prove beyond a reasonable doubt. You get out. You have every incentive in the world to make sure that that knife, gun, whatever, is hidden, right? Is destroyed, is whatever. You have every incentive to make sure that the prosecutor and the police don't get their hands on evidence that can be used against you, right? And that's what obstruction of justice really comes into play, is you're destroying evidence that you know will come in against you. That's not self-incrimination or anything like that. We also look and we ask, will you or may you, if we will only hold you in preventative detention if you may threaten witnesses or jurors, right? So again, this brings back the presumption of innocence, but let's say you have 2 or 3 assaults that you're being arrested for. Well, you may pose a threat to the community, but you also may threaten witnesses or jurors. Now, this is usually in TV shows, and it's actually not too far from the truth, but this is kind of like where the mob comes into play, right? Where we have some reason to believe that you're associated with mafia or some other organized crime gang, and you have the ability to threaten witnesses, threaten jurors to throw their testimony or to vote a certain way. Because it's an interesting situation to be in. It doesn't come up all that often, right? Because I mean, theoretically, anyone could have incentive to threaten a witness or a juror, right? Especially if they knew it, or make them change their testimony. But if it's to the point that you are tampering, well, then that's where we have the problem. And when we're talking federal crimes, we will only hold somebody in preventative detention for certain enumerated crimes. So in the statute, it says that we have a presumption of pretrial release. There are certain crimes, so certain drug offenses, violent offenses, and capital cases in which we have the rebuttable presumption of preventative detention, right? So going into it, we assume that you are not getting bail, but you do get the right to argue for bail, right? So usually, again, keep in mind, this is from the Bail Reform Act of 1984. So drugs, obviously a big problem. That's the one that you can mostly, especially if you're not dealing, is the one that you can usually get off and break the presumption of preventative detention. Violent cases, this is less likely. Again, especially at the federal level, because we're talking you did something to a federal employee or you crossed state lines to do something, like the violence is there. So that one's really hard to get around. And then of course, capital cases, you're virtually never going to get a bail in a capital case. Again, the thought process here is, especially at the federal level, they have the death penalty. Why wouldn't you run, right? Like, especially if you know you're gonna be found guilty. I'd run. Even if I was innocent, I'd probably run, just because how the system works. So capital cases, generally, you're not going to be able to rebut the presumption, but you are given a chance. So being said, when you get a chance, in your text, there is United States versus Salerno. Take a look at it. It deals with this idea of bail and returning for trial. So we talk about preventative detention. Right? If a defendant is held without bail, substantive due process requires that pretrial detention not be punitive. Right? So due process says, look, you haven't found them guilty of anything. They're presumed innocent, so you can't punish them with pretrial detention. Now, when we say it cannot be punitive, generally speaking, you're treated like every other prisoner, right? So we can only use it to prevent things, but theoretically, it looks exactly like everyone else in jail. Keep in mind, you have people in jail who are awaiting trial, like you are presumed innocent, but you have people in jail who have been found guilty of a misdemeanor and they're spending a year or less there. Or you have people who've been found guilty of felonies, even violent felonies, right, who are in jail, awaiting for a bed to open up in a federal or state prison. So you're in there in the mix with people who have been found guilty of very serious things. And you're treated the exact same, right? So you don't get special privileges just because it's preventative. No, you wake up at this time, you have this, you have to pay for phone calls, you have to all that stuff, right? So there's really, really hard to see any difference. And Bell versus Wolfish, which is the greatest last name in the history of the world, so I just want to say Wolfish, like 2 F's. But Bell versus Wolfish gets into this idea of preventative versus punishment. And generally speaking, like I said, you're treated exactly the same as maybe somebody who's been found guilty of capital murder. Now, these are usually county jails, and everybody's just kind of in the mix. There are, in bigger cities, bigger jails. For instance, the Cook County Jail, which is the jail that is the Chicago area, they have different classifications, right, of prisoners. So they have prisoners who they say are not dangerous. They have prisoners that are dangerous. Or they have basically minimum, medium, maximum, and supermax security inside the jail. And they assign things based upon defendants' crimes, based upon all kinds of factors. But again, that's where things get even more iffy, because what if you say somebody is a medium threat? Well, they're innocent, right? We have to presume them innocent. So how are they a threat? So that's where, again, we really kind of tongue-in-cheek say that you're presumed innocent. In reality, we presume you guilty. That's why we're holding you. Similarly, if a defendant is held without bail, they have procedural due process, which requires that the decision be subject to periodic review. Right? So every so many months or every so many days, the person that's in jail has to be brought back before the judge and we review whether bail is appropriate now, whether things have changed, how have you behaved in jail, things along those lines. Now, at this point, we're still at the same clear and convincing evidence standard, right? So the prosecution still has the burden to prove by clear and convincing evidence that you are a flight risk or that you are a danger to the community, whatever, right? They still have that burden. Now, this is subject to cross-examination, so a defendant can cross-examine the plaintiff's witnesses, but cannot generally call their own witnesses, right? So defense, you can't call your own. So again, this is very, very similar to what we just discussed, but you get periodic review. Now, if we're talking a statutory enumerated offense, then you still have to have the periodic review, but the tables are turned, right? And you have to rebut the presumption that we should hold you in jail. And again, a lot of things come into play here, how the case is developed, the strength of the case, the weaknesses in the case, blah, 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 blah. But we also take into consideration how you behaved in jail. Like, how have you done so far? If we think you're going to be a threat to the community, but in jail you've been like the model prisoner, right, doing everything that you can to correct yourself or to prove that you're worthy of bail or whatever, well, then we might say, well, yeah, they're no longer really a risk to the community. They seem like they're doing really well. Maybe we give them a chance. You set a bail, but you maybe give them a chance, right? This does happen. Now, that being said, all bail, issues of bail, so let's say you get bail of $100 and you can't make it, or preventative detention, right? So your flight risk, things like that, are appealable all the way to the Supreme Court of the United States as a matter of right, right? So remember we talked about justice system, we said you get one appeal as a matter of right, and then the Supreme Court at the state level usually, or at the federal level absolutely, has discretion in determining what kind of cases they're going to hear, right? So, the Supreme Court of the United States may get 16,000 petitions, people asking for them to hear their case a year. Of that, they maybe take 100, right? Because they have basically just the utmost discretion. But because it's an Eighth Amendment right, you have the right to appeal your bail or preventative detention determination all the way to the Supreme Court, and the Supreme Court has to hear it. Now, it won't be the full Supreme Court. So basically, there's a justice on the Supreme Court. Each one sits over a circuit or circuits, and whatever circuit you're in, that's the justice you appeal to, right? And the decision is made by the single justice. It's not made by the full court, nor are they going to take you to Washington, D.C. so that you can meet the justice? No, these things happen over Zoom. They happen telephonically. It just kind of is what it is. Now, that being said, right, you are allowed to appeal your bail or your preventative detention determination all the way up, but you're not guaranteed anything, right? So theoretically, your bail can go down, right? Your bail can stay the same. And here's the risk: your bail can go up, right? So if you say you want to appeal bail from a court of limited jurisdiction to a court of general jurisdiction, and your bail is set at $100, and this jurisdiction, the next court looks at it and says, no, we think $500 is more appropriate, right? And you just keep appealing, and you go up to the Supreme Court, and at this point, your bail is still $500. You are annoying a Supreme Court justice about not being able to make $500. That justice is probably going to slam you with a very, very heavy bail. Again, not supposed to be violating the Constitution or the Eighth Amendment, and not supposed to be more than necessary. But if you've done that, they're probably going to slam you. Now, that being said, If you have a bail that you cannot meet, like literally, you know you're not going to meet it, you can't get out of jail. Why not? Right? Why not appeal all the way to the Supreme Court? Most, the vast majority of defendants don't appeal their bail beyond maybe the next highest court. But most of them, very, very few, handful ever go to the Supreme Court. But if I'm sitting in jail, and in jail, there's nothing for you to do. So that's one kind of a key distinction here is the difference between jail and prison, right? In jail, there's no really programs to better yourself. You maybe have, if you're lucky, have a library, probably not. I was thinking about the county jail where I grew up, like it literally was, there were some tables, metal tables in the center, and then cells. Like that was it. There was nothing. So, why not? You have nothing to lose. You can't make the bail. Why not? Right? And it'd be cool because you can be like, yeah, I went to the Supreme Court. But it is what it is. But also that does bring into something I want to say is, generally speaking, if you're found guilty of a crime, you're going to want to get a bed in prison as soon as possible, right? Because prisons have programs, right? They have libraries, they have GED classes, they may have free college classes. They have a lot of stuff. Again, it's not the safest of places and you don't want to be there, but it's better than literally just sitting in your room staring at the ceiling for a year. Right. So again, this is why I would recommend that everyone appeal all the way up unless they can make it. If they can't make it, then why not? Why not shoot for it? Right? Worst thing they're going to do is tell you no, or they raise your bail. Like you can't make $25,000, and they say, oh, we're raising it to $50,000. For me, I'm poor, right? Like $25,000 for me, I'm not making that. $50,000, I'm not making that. Like 25,000 might as well be 50,000 because I can't make it. So why not? That being said, there is a link in the PowerPoint slide to a sample bail hearing. I encourage you to take a look at it because it does provide really good reference. Actually, we'll take the time here. We are recording with sound to watch the bail hearing. Now, it might be a little difficult to hear, so I recommend you turning it up. But here's what you see just from the back, right? On the very left-hand side, you have a lawyer and a guy who's in orange, right? Behind him is the bailiff, ready to take him. And generally speaking, he's probably not going to be uncuffed or anything like that, because bail hearings are relatively short. On the other side, you have the prosecutor, and there's nobody else with him. But you'll notice, like, there's no jury. So since there's no jury, we don't care if the guy is in prison orange, right? We don't care. It just kind of is what it is, right? It's just the judge, and the judge sees this all the time. It's not going to be affected either way. But I'll play the bail hearing for you, and then we will continue.
We are back on the record. Mr. Michelik, you're going to be representing Mr. Cooper?
I am today, Judge.
All right, go ahead, Mr. Pellerani.
Your Honor, shortly after noon on Sunday, August 19, the suspect, soon to be the defendant, Brian M. Cooper, made a telephone call through the 911 system from a gas station convenience store located in the village of Sister Bay. Mr. Cooper, when he got a hold of the 911 dispatcher, he reported to her he wanted to report a murder that he had committed of his friend, Alicia M. Bromfield. Then during about a 15 to 20-some minute phone call with the dispatcher, he filled in more details about what had happened. As that conversation was going on, the Sheriff's Department conversation with the dispatcher, and then later in a more formal interview with an investigator with the Sheriff's Department, reported that he has known the victim for a number of years, that the two worked together, and in fact, I believe he worked in a supervisory capacity over her in the area where they both lived in Illinois, and that at some point he believed their relationship had gone to a different level, not just friends or co-workers, but had become a romantic relationship. That was a little over a year ago. She then went back to college in the summer when she resumed working at that same employment place. He noted a difference in their relationship, that they were, quote, just friends, end quote. He wished it to be more and wanted it to be more and hoped it would be more. And he invited her to a family wedding that was going to be taking place in Door County this weekend for the express purpose of hopefully having that relationship go to a more romantic level that he wished, but she clearly did not wish. When they arrived in Door County, he soon found that her attitude was not at all in line with his. In fact, they argued Saturday morning on the morning of the wedding for a time. He was intending to not even go to the wedding. They somehow made up enough to go to the wedding. He drank throughout the evening. She did not drink at all because she is 6.5 months pregnant. After the end of the party, they returned to their hotel at the Sand Bay Beach Resort located in Door County. And there he talked with her again about whether they had any future. He specifically talked about some plans for doing something here in Door County the next day. She told him no in no uncertain terms, and that she was just going to go home or wanted to just go home. And she then went to sleep. He then proceeded to sit in the room growing more angry and frustrated, not only at the breakup of their relationship, but at his feeling of her apparent coldness and indifference to him during the course of the evening. He then awakened her about sometime between 2 and 3 in the morning, got on top of her, and with his hands he strangled her to death. After killing her, he then undressed her and undressed himself, and he had sexual intercourse with her body. He then fell asleep. He woke up a few hours later, and it was then, he says, his intention, realizing what he had done, to kill himself. He made a number of attempts with a butter knife on his wrists and his neck, with a corkscrew wine opener on his wrists. Then he got in his car and was driving around the county for the purpose of coming up with some idea for how to kill himself. When he got somewhere north of Sister Bay, he says, he went into a park in Ellison Bay, went into the bay and tried to drown himself. When deputies located him at the convenience store gas station in Sister Bay, he had no shoes and his clothes were all wet, consistent with what he described having happened. So for those reasons, within the next few days, my office will be charging Mr. Cooper with 2 counts of first-degree intentional homicide, one for the death of Alicia Brownfield and another for the death of her unborn female child. I'll also be charging with 1 count of third-degree sexual assault of a child. Mr. Cooper has, to my knowledge, virtually no contacts whatsoever with either Door County or the state of Wisconsin. He lives and works in Illinois and has for a number of years. There really isn't any bond high enough, I think, to guarantee his appearance. So the number that I'm going to be suggesting is simply a number, Your Honor, I think that is big enough to guarantee he won't be able to make it, because I don't think there is any safe way to guarantee his appearance while out on bond. So I would ask for a $1 million cash bond for Mr. Cooper, and that's all that I have.
Mr. Michelli, do you wish that I inquire Mr. Cooper, his address and phone number and other information, or did you get that information from him?
I did get that information from him.
Why don't you go ahead and give me his address, please?
He lives at 2437 Oak Tree Lane in Plainfield, Illinois, 60586.
Did he indicate to you how long he's lived there?
He's been a homeowner there for 7 years.
Okay, thank you. Telephone number?
630-973-7522.
Is he employed?
He was employed until his arrest at Grand Service. He was a regional manager
Wisconsin resident. So I concur with the state that a very high bond is warranted in this matter, and I will, as I've stated already, set one in the amount of $1 million. You will need to be fingerprinted and photographed by law enforcement, which has probably already occurred. Mr. Pellrine, are you anticipating in terms of an additional appearance in this matter? The timing of that?
If it was absolutely needed, we could have a complaint ready on the 23rd of August. I will not be here then, but I guess I would wish for more time, if for no other reason than while I've gotten some oral descriptions of the results of the autopsies rather, only occurred yesterday afternoon, and it's going to be days, if not a week, before I actually get written reports describing the full extent of the injuries to Ms. Brownfield and confirmation of what I've been orally told was the cause of death of her and the unborn child.
And I believe you said yesterday you are out all next week.
That is correct.
Right. So you would be available next week to do the initial appearance.
Correct, and that's why I knew that you have court on Monday the 23rd, and I was just assuming that that would be the only initial appearance date you'd be doing for that week.
Well, that's this week, Thursday.
I'm sorry,
next week.
Monday the 27th, excuse me.
Monday, I am not having intake. I'm gone all next week also.
Okay.
So that's the other complication here. And considering the cash bond that I've set, that based on Mr. Michalek's statements, doesn't appear the defendant's going to be able to post that, I don't think we should be waiting 2 weeks before we have an initial appearance. I know, Mr. Michalek, any comment on that from your standpoint in terms of the timing of the initial appearance?
Yes, Your Honor. Based on the information that Mr. Cooper provided me, my office will, I'm sure, want to look into and verify what assets he does or does not have. So it's possible that he will not be qualified for public defender representation. I don't know if his family plans to hire an attorney privately, or if he would be asking the court to appoint an attorney at this point. But I did want to appear with him today to make sure that he is represented.
Well, based on those statements, then, gentlemen, I feel we can set this for sometime the week of September 4th. I'm looking at setting an initial hearing.
Okay, so what you just sat through was a bail hearing. Now you heard them referring to making an initial appearance. That's because he's hasn't been completely formally charged, but he's been arrested, right? And so they're setting the bail for him because he's been arrested. Obviously, in this case, the state, if you couldn't hear, is charging the defendant in a murder case, right? Charging him with the murder of somebody who wanted to be his girlfriend and her unborn child, right? So when he killed her, the fetus died as well. Again, this is Wisconsin, so depending on how we define life, depends upon if this would be a realistic charge or not. I'm guessing because it's Wisconsin, the answer is yes. And also sexual assault in the third degree for having sex with the body following its death. And yeah, you heard defense say, like, because the defense knew, right? They're like, you have to put up some kind of defense. But he said, yeah, $500,000. Probably not going to make that, right? And you're probably not going to make $1 million. But the judge said something really interesting, right? He's like, well, it doesn't sound like you're going to be able to make the $1 million. So, maybe we should speed this up a little bit. Well, again, the idea here is not punitive, right? It's to ensure the return. But by setting the bonds or the bail so high, they've basically made it so that he will not get out of jail, right? So that's kind of where they were at. Granted, he was an out-of-state resident, right, visiting the state, etc. So, I mean, there is just cause, I think, for a very high bail in this case. But the defense argues for half the bail, like $500,000, just to put an argument really on the record. And then the most of this is just scheduling the hearing. So, what you did see towards the end of that clip, right, was the scheduling of the initial appearance and discussion as to whether the defendant would qualify for a public defender or whether his family would have to hire one separately. So that invokes the constitutional amendment number 6. Okay? In all criminal prosecutions, the accused shall enjoy the right, and then we jump all the way down, to have the assistance of counsel for his defense. All right, so what we're going to kind of turn to now is, what does that mean? Right? When do you get a public defender? When do you not? How does that system work? So generally speaking, if we look at the development of the right to counsel, historically, under English common law, defendants were denied the right to counsel for felonies. Right? You could have them for misdemeanors, but not for felonies. And felonies all carried a possible sentence of death. Lawyers were seen as, quote, corruptors that impeded prosecutions. Right, so the idea was the prosecutor could just go forward, and we didn't have really much of a presumption, and the defense counsel would just make things worse. So we didn't let them have defense counsel. Now, under some interpretations of Sharia law, this connotation remains the same. So if you're in a jurisdiction that practices Sharia law, you may not get a lawyer, because if we do the translation from Arabic to English, the term corrupter comes back into play, right? So it depends on the situation, the circumstances, but generally speaking, if it's a pure Sharia law jurisdiction, which there is none, you might not get counsel, just depending on the court's interpretation of the law. Now, again, this is back in the day, right? When we think of the right to counsel, it's actually very much a Western concept, right? So this idea of lawyering as a profession really is a Western concept. So when we think of like the United States, law degrees in the United States are a graduate degree, right? So you have to go to undergraduate first and then go to law school. In England or other countries, a law degree is an undergraduate degree, right? So you major more or less in law, and then you do an apprenticeship, and then you become an attorney or a solicitor or a barrister, depending on the path that you choose. So we have graduate degrees, right? And that's what makes American lawyers very unique and very sought after. So if you ever have the idea that you want to practice abroad, the fact that you are an American lawyer means that you are very highly sought after, because you have gone through undergrad, then you went through 3 years of pure law and pure hell, but you have the doctoral degree. So this is where it becomes really important. Now, that being said, even though it's a very Western concept, and we've developed this idea of lawyering throughout time, the development of the right to counsel in the United States reflects a historical hesitancy to give people attorneys, right? So one of the cases on point is Powell v. Alabama, which is a 1932 case in which African-American male is charged with, if my memory is correct, murder. And I think it was murder of a white woman, right? Which the fact that they didn't lynch him is a surprise. And I don't like saying that, but it's true. But what happens is he doesn't have a lawyer, right? And it's a capital case. So at the federal level, all right, the right to a lawyer is fairly clear, right? The Constitution says you get a lawyer. So we're talking about the states, right? This is Alabama. It's a capital case. And what actually happened is, like, nobody wanted to be his attorney. right? Because like nobody wanted to be in that position. This is like historical, really bad race issues, all that stuff. So what actually ended up happening was the judge appointed every attorney in the state of Alabama to be this guy's attorney. It was just a fascinating case. But we get to the Supreme Court, and the Supreme Court says, okay, for people who are indigent, so they can't afford it, in capital cases, under limited circumstances in state cases, will you have the right to counsel, right? And so when we say capital cases, right, we're talking death penalty or life without parole, limited circumstances. So Powell v. Alabama said, look, only if these are present, right? It's a capital case, and in this case, they're incapable of presenting a defense because of, quote, ignorance, feeble-mindedness, or illiteracy, right? So they can't read, which at this point in time, a lot of African Americans couldn't. Again, we were talking, the schooling was just underfunded for Black schools, and white schools got all the money. So, you know, we have illiteracy, ignorance, feeble-mindedness, like the idea of if somebody is has an intellectual disability, something along those lines, right? So basically, this was a result of an extraordinary set of circumstances. So the Supreme Court said, yeah, states have to provide a lawyer, but if it's a capital case and assuming that the defendant is ignorant, feeble-minded, or illiterate, the state has to provide an attorney. So it didn't give attorneys to everyone, right? At the federal level, you have an attorney, the Constitution applies to the federal level. But at states, it didn't. So the Supreme Court saw the, quote, right to counsel as a question that was confiscated by federalism, right? So if we look at a couple of cases, we start to see them expanding this right to an attorney, right? So we look at a 1938 case, Johnson v. Zurst. It recognizes the right to counsel for indigents in federal cases, right? Because it's fairly clear that the Constitution says you have the right to counsel, right? But the Constitution doesn't say you have to be poor or they have to give you one for free, but it's just how we interpret it. If you're indigent and can't afford a lawyer and you're on federal charges, you get a federal lawyer, right? Usually a public defender. Now, only 6 years after Powell, right, but still declining to extend the right to state prosecutions beyond those imposed by Powell. And so it basically said, yeah, indigent, any federal case doesn't have to be capital, and you can't afford it, then you get a lawyer. But it declined to say, we're going to put this on the states, right? So then we jump ahead about 4 years, and we get to Betts v. Brady, a very important case. It's a 1942 case, and what it did was interesting. It officially refused to extend the right to counsel in state cases. Right, so it's like, no, you don't, in states, they can give you counsel if they want to, but the Constitution doesn't require that they do. That being said, Betts v. Brady did recognize a, quote, special circumstances that were expounded in Powell. Right, so basically what the court said is counsel may be required to represent young offenders with little education or mentally challenged defendants with complicated crimes involving technical defenses. And so this is the special circumstances. They finally tell us exactly what the circumstances are. Again, somebody who's young, little education, mentally challenged, and they're charged with a complicated crime involving a technical defense. So we're talking very, very limited circumstances, right? There's special circumstances. That goes all the way to Gideon v. Wainwright, 1963. You take the class judicial process, we get into Gideon versus Wainwright a lot. You'll be reading Gideon's Trumpet as a part of the class because it's just such an amazing case. Basically, Gideon was a a low-level offender, right? He was kind of he was a drifter, right? And he was accused of breaking into a pool hall and smashing a vending machine and taking all the coins out, right? At trial, when he asked the judge, he's like, I get a lawyer. And the judge is like, what? No. He said, but the Constitution says, and the judge is nice to him, but he's like, no, you don't get a lawyer. And so Gideon has to get up and question witnesses and things like that himself as they go to trial. And he actually does a fairly good job, right? He never had really any formal education. He can read and he can write. That's about it. But he did a fairly decent job of questioning witnesses. Now, he didn't call any in his own defense, and there were a lot of questions he should have asked that he didn't ask, right? So he gets found guilty, and he gets sentenced to state prison in Florida. And what he does is he appeals all the way up to the Supreme Court. He writes out a petition, a handwritten petition, in form of paupers. So in the form of a pauper. It's basically saying, it basically asks the court, hey, I know you have a lot of rules that we have to follow for you to even take our case, but I'm really poor. I can't afford to do that. Take this case. And basically, Gideon writes out the his appeal on yellow legal pad paper, right? So it's all kind of handwritten. I mean, riddled with misspellings and weird terms, but he's saying that he deserves right to counsel. So one thing that's really important is this is a 1963 case, right? So this is during the criminal justice revolution under Chief Justice Earl Warren. So Warren and some of the more liberal members of the court were looking for a case that would be perfect to extend counsel, but they kind of already had their mind made up. So they get Gideon's petition, and the rule of 4 applies. At least 4 voted to hear Gideon's arguments that the states have to provide lawyers. And at this point, because the Supreme Court has taken it, it's now a federal case. So Gideon gets a lawyer, gets appointed counsel, a very, very famous lawyer who later becomes a justice of the Supreme Court. Like, this is how important this guy is. And ultimately, the court says, no. And we're overruling Betts v. Brady. We're extending the right to counsel to state prosecutions. So not only in federal prosecutions do you get the right to counsel, you also get it in state prosecutions. Right? Again, this was something that changed a hallmark. So what ends up happening in Gideon v. Wainwright is the state of Florida retries Gideon, and this time with a lawyer. And they call some witnesses and they question some witnesses. One of the witnesses they questioned was really, I mean, he was obviously the one who did it. He was guilty. The witness was guilty. Like, he's the one who did it. He was just framing Gideon. And he doesn't ever admit it, but it basically comes across that way, right? And so what ends up happening is Gideon's actually acquitted, right? They find him not guilty. And it's an amazing case because he was factually innocent and needed an attorney. Like, that's why this case is so important. An innocent person couldn't do it themselves, right? A guilty person couldn't do it themselves. But the idea here is you get the right to counsel at the state level as well. So let's talk about the scope of the right to counsel, right? Because again, this has been developed via court cases and really the rules of procedure and things like that. So that being said, the right to counsel attaches when, quote, formal criminal proceedings are initiated, end quote. So normally this is going to be the initial appearance, right? Now, when we talked about the right to counsel, we are being questioned. That was the Fifth Amendment. right? Because again, you're at this point, at the Fifth Amendment, you're not charged with anything yet. You're in custody and you get a lawyer, right? Now, because you've been charged, right? Now that we have moved on, we move to the Sixth Amendment, and that's what we're talking about now, is the Sixth Amendment's interpretation. So generally speaking, when we talk about the Sixth Amendment's interpretation of when you get a lawyer, what the Supreme Court has told us is it applies to all, quote, critical stages of the prosecution, end quote, which are likely to affect the ability to present a defense. So what this means is you get a right to counsel at your initial appearance or an arraignment, preliminary hearing, the post-indictment lineups, custodial interrogations. So after the proceedings have started, like they can't ask you any questions, they have to go through your attorney. Plea bargaining, trial, and sentencing. Those are ones that can have an effect on whether you're found guilty or whether you're found not guilty. Now, these are critical stages. Generally speaking, you don't have the right to counsel at grand juries because those are closed private proceedings. And they're not finding you guilty or anything like that. They're just deciding probable cause. And I'll say it this way, you're not technically afforded the right of an attorney at a bail hearing, like we watched a few minutes ago. However, you really do get a lawyer for the bail hearings. It just depends on the state. Like Massachusetts, everybody got a public defender for the bail hearing, and then they worried about who was going to appoint counsel, how much money you make, all that stuff. So again, it just depends on the jurisdiction, but generally speaking, you will get counsel for bail hearings. That being said, this only applies to critical stages of the prosecution. So let's say that you have a motion here, right, for your counsel files for a extension of time, right, and the prosecutor wants to fight it. Well, that might not be a critical stage, so you're not entitled to a lawyer. Now, it doesn't mean the lawyer can't be there and do their job. That absolutely they can and they will, but they're not required. But I want to express how low of a bar this is, right? Because there have been cases, even a death penalty case, where lawyers have come in and drunk, or in the death penalty case, and this was in Texas, the lawyer fell asleep during the trial and didn't question witnesses or anything like that. And the Supreme Court has looked at those cases and said, well, they were coherent or they were awake for the important parts, like the critical parts. So, that's all you need. So we define this like effective counsel very, very narrowly. So Getting v. Wainwright generally applied to the states, felonies. Scott versus Illinois kind of blurs the lines on the right to counsel for state misdemeanor charges. Basically, it articulated a rule that an indigent defendant cannot be sentenced to jail unless he has been afforded the right to counsel. Right? So I'll say that again. The rule is a defendant cannot be sentenced to jail unless he has been afforded the right to counsel. Right? So if it's a misdemeanor and you don't get a lawyer, the most that they can do to you is give you a fine. They cannot put you in jail. And that's where Scott v. Illinois kind of comes into play, how it blurs this line. And that's just kind of like the middle ground that we get from it. Now, that being said, V. Wainwright, Scott v. Illinois, they all apply to indigent people, right? And the federal level applies to indigent people. Now, how do you define if somebody's indigent, right? Well, we have left that up to each state to determine for themselves. Right, so for instance, Washington State will appoint counsel if 1, an individual is receiving public assistance, or 2, an individual makes less than 125% of the federal poverty level, or 3, the individual does not otherwise have sufficient funds to pay a lawyer. On the other hand, if we look at Massachusetts, it uses a complex sliding scale where you put in what your assets are, what your house is worth, all this stuff, and it's this weird, like really complex sliding scale. I encourage you to click the link and take a look at it because it is so fascinating. So states, they get to define what indigency is. And they all do it differently. Like I said, if you compare Massachusetts to Washington State, there's a big difference. Now, are the same people getting public defenders? For the most part. But there are some people who qualify for public defender in Washington, but would not qualify for public defender in Massachusetts. So we don't have any really good case law that says this is the level of poverty that somebody has to be at to get a public defender. Generally speaking, if it's a capital case, you will get a public defender regardless of, even if you're a millionaire, you have the right to a public defender, usually 2, one who's done the capital case before and one who has or hasn't done a capital case before. Again, because of the severity, we just give them lawyers. And I mean, if you're a millionaire, you're going to you can get your own lawyer. Like, that's not a big deal, but you still get the right to a public defender if you want one, right? So that's kind of our rule that we've come down to. So if we get to Morris v., and I love this one, Slappy, another great name. It's a 1983 case, right? So what this case holds is that indigent defendants do not have a right to select the appointed counsel, right? So basically you don't get to choose who your lawyer will be, right? The court chooses. Usually it's the public defender's office. Some jurisdictions, you basically have to take turns. Like you get on the list and you get a case. So there's a lot of different ways that counsel is actually appointed, but you don't get the choice. Now you can fire your counsel, and usually they'll give you like one chance at a new lawyer. But if you fire that one, well then you've lost your right because you were appointed counsel and you fired them, right? So we did what we were supposed to do. We gave you a lawyer. You can't fire them until you find one you like, right? You get what you get. Now, this is often causes mistrust among indigent clients because what they're going to do is they're going to later claim, as I mentioned earlier, that they received, quote, ineffective legal representation, which is a violation of the Sixth Amendment. So ineffective legal representation, right, which would reverse the case, given a new attorney, whatever, is difficult to prove because it requires the client to show a, quote, reasonable probability. And we never really put a number on this, but it's probably higher than probable cause. Maybe it's probable cause if we think about it kind of in the abstract. But they have to show by a reasonable probability that the results of the trial would have been different, but for the attorney's actions. Right? So basically what you have to prove, and you have to prove it as the person who's making the appeal, you have to prove that because your attorney didn't do X, Y, and Z, you wouldn't have been found guilty. Right? So like you have to show that you wouldn't have been found guilty by reasonable probability had your lawyer done X, Y, or Z. So this, I mean, very, very difficult to prove, rarely succeeds. We do judge it under the totality of the circumstances. So we look at everything and say, well, yeah, the prosecution had a really strong case. So even if they had called this witness, you would have still been found guilty, probably, right? So At this point, remember, you are guilty. You have to prove that you're not, or at least that the attorney's actions made it in such a way that you wouldn't have been found guilty if they'd done their job. So this is a very high bar. And keep in mind, judges, for the most part, especially at the appellate level, are lawyers. And it's kind of a club, more or less. And very hesitant to say that somebody would have been, is an incompetent counsel, right? Because that can lead to all kinds of problems for them. So it's a very difficult thing to prove. It's even more difficult to prove in civil lawsuits, because in civil lawsuits, you have to prove you're actually innocent, right? It's not that if the lawyer had called this witness, the jury wouldn't have awarded damages or whatever. You have to show that, yeah, lawyer didn't call these witnesses, whatever, but I'm innocent. Here's the DNA test that shows I'm innocent. You have to prove it. So again, we're talking really high bars. If you're trying to plead an ineffective assistance of counsel, you're not going to get far. So what is the minimum standards of effective counsel? So an attorney's performance is, quote, effective if it meets 4 minimum standards, right? So a lawyer has knowledge of the law, right? They have a duty to investigate. They have a duty of consultation and information about a case's immigration consequences, right? So if the lawyer knew the law, if the lawyer investigated, if the lawyer consulted with the defendant, talked to the defendant, and if the lawyer told the defendant that if they were found guilty and they were an immigrant, they could be discharged from the country, blah, 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 then we're going to say they're effective, right? Like that's it. That's as low as it can go. And when we think of like knowledge of the law, that's a really low bar too, because we presume that anybody can know the law, right? So all you have to do is study up on the law, and you know it. So we presume that maybe all you do is personal injury claims, and you get a felony misdemeanor, or excuse me, a felony breaking and entering claim. That's not your area, but we're going to presume that you can look into it, learn it, and then be effective as counsel. So that's kind of generally what our 4 standards are. And again, that's a really low threshold. Now, with this low threshold, attorneys always get a bad rap, especially criminal defense attorneys. And as a former one, like, it makes me sad because, like, I don't like the connotation. But what most people don't realize is in providing this representation, even if you're claiming ineffective, an attorney is under no obligation to break legal rules. So an attorney cannot subordinate perjury, right? So let's say that the defendant is insisting that they take the stand. Well, at the end of the day, it's their call. If the attorney is going to warn them not to, please don't do it, like beg them not to, but they'll do it. And they talk to you about like what your testimony is going to be, and you're saying, oh, yeah, and like this person's guilty because they told you they're guilty, and they told you how they did it and all this stuff. He says, oh yeah, I got a friend who says that he'll say that I was there, and I'm going to say that, and I'm going to say this, and this, and it's lies. In this case, the defense attorney can only ask one question, right? And the judge will know what's happening. So what happens is the defendant gets on the stand, and the defense attorney, the only question they can ask without subordinating perjury is, tell us what happened. That's it, right? They can't, and then the defendant has to give a narrative, right, of everything that happened. This will show to everyone in the courtroom, including the judge, that yeah, this guy is lying. but you as a lawyer know he's lying, but you're not helping him lie, right? So you cannot tell the judge, hey, he's guilty, don't let him testify. You can't do that because, again, you have the obligation of being confidential, but you can't subordinate perjury. You can't break the legal rules. So there's ways that we do it. We do things so we don't break legal rules, but still abide by the Constitution. Now, that being said, generally speaking, the attorney controls the strategy of the case and receives significant deference if the strategy is reasonable, right? So again, this kind of goes back to if they're effective, minimum standards, they can't break legal rules, right? And if they choose a path, a defense that's kind of off, then so be it, as long as it's reasonable. So being said, I have a challenge for you. I have a challenge that you look at Hinton v. Alabama. It's a 2014 case. And read through it and ask yourself, is this an effective representation by counsel? And then read what the court says. It's a shocking case to a layperson, right? It's a very interesting case. Just take a look at it. Now, that being said, you have the right to, it's nearly an absolute right to represent yourself, right? So if you represent yourself, it's referred to as pro se, right? But that being said, there is the old saying that a defendant who represents themselves has an idiot for an attorney, which is true. Especially if they're going to give you an attorney, and you choose to represent yourself, it never ends well. I saw a case where a guy was on criminal charges and he was representing himself, and it was painful to watch because there are certain rules, certain procedures that we have to follow as lawyers. And generally speaking, if you're pro se, we're going to give you a little bit of rope, a little bit of latitude, but you can't violate certain rules. So in order to proceed pro se, an indigent defendant must be given notice of the charges, notice of his or her right to counsel, and notice of the possibility of the punishment. Right? So as long as the defendant understands or knows what the charges are, that they have a right to counsel, and what the possible punishment could be if they're found guilty, then we'll let them proceed pro se. Now, if the defendant wants to still proceed pro se, his or her waiver must be unequivocal and subject to notice, competency, and disruption. So when we think about notice is you can't say at the last minute, I want to represent myself. Or vice versa, right? Like you're pro se the whole time. You have to give the court time to decide whether that you can proceed pro se and to appoint standby counsel as necessary. So you can't do a last minute decision to say, I'm just going to do this pro se. We also look at competency, right? And deciding whether somebody can waive their right and be pro se. And competency, we're talking a very low threshold. We're just talking about competency in general. You don't have to be competent on the law, don't have to be competent on procedures, whatever. You just have to understand what your charges are, that you have the right to counsel, and you have the possibility of punishment. And as long as you are competent, so you don't have an intellectual disability or something like that, you can represent yourself. Now, that being said, you can lose this right during or before trial if you cause a disruption, right? So if you start yelling at witnesses you're lying and interrupting the prosecutor and not abiding by the rules of the court, and you're doing it intentionally to be disruptive, they'll appoint you counsel. They'll say, no, you're done being pro se, and they'll appoint counsel. So what courts often do if somebody wants to be pro se is they appoint what's called standby counsel, or they're also called shadow lawyers, shadow attorneys, shadow counsel. And what they do is the lawyer who gets appointed as standby counsel sits in the courtroom and listens to everything and takes notes about everything that's happening in the courtroom, right? Because the pro se defendant at any point can waive or unwaive their right and ask for a lawyer. At any point can ask for a lawyer. So this is why lawyers will, or courts will appoint standby counsel, shadow counsel, is because you don't get a new trial just because you decided to change your mind and you changed your mind and you decided you need an attorney. You don't just get a new trial. Instead, we have standby counsel, and standby counsel comes in and runs the rest of the case, right? They don't get to do anything really I mean, they try to mitigate what you did pro se, but they try the rest of the case. They don't start over with an attorney, right? So, but you can ask for an attorney at the very last second. And I want somebody to do closing arguments for me. Okay. Then your shadow counsel will get up there and do closing arguments. Right? So they'll be in there most of the time. So that being said, thank you for taking your time to listen to this lecture. Next class, we will look at preliminary hearings, grand juries, and arraignments.